Hello, I'm Kimberly Berry. This video will provide a brief overview of laws which govern how schools provide assistive technology for students with disabilities. The three laws which relate to assistive technology in the public schools are the Individuals with Disabilities Education Act as reauthorized in 2004, the Rehabilitation Act of 1973, and the Americans with Disabilities Act of 1990. The Individuals with Disabilities Education Act defines assistive technology devices and services and requires that schools ensure the needed AT is provided at no cost to the student who needs it. An AT device is defined as any item, piece of equipment, or product system, whether acquired commercially off the shelf, modified, or customized, that is used to increase, maintain, or improve the functional capabilities of a child with a disability. The term does not include a medical device that is surgically implanted or the replacement of such a device. An assistive technology service is any service that directly assists a child with a disability in the selection, acquisition, or use of an assistive technology device. IDEA references AT in a couple of areas. 34 CFR Section 300.105 says that each public agency must ensure that assistive technology devices or assistive technology services, or both, are made available to a child with a disability, if required as part of a child's special education, related services, or supplementary aids and services. On a case-by-case basis, the use of school-purchased assistive technology devices in a child's home or in other settings is required if the child's IEP team determines that the child needs access to those devices in order to receive a free and appropriate public education, or FAPE. 34 CFR Section 300.24 gives IEP teams the responsibility for deciding what AT a student may require. Teams are directed to consider AT in the development, review, and revision of the IEP. An important point to note is the time factor. IDEA says that schools may not unnecessarily delay the provision of AT devices and services due to funding issues if a child requires the devices and services to benefit from the IEP. The next law we'll look at is the Rehabilitation Act of 1973, which prohibits discrimination against individuals with disabilities and requires schools to provide equal access to their programs and services. Section 504 references assistive technology in special education, related aids and services, and supplementary aids and services. And something to consider is that a student is not required to be eligible for special education services to be protected under Section 504. The third law covering AT in the schools is the Americans with Disabilities Act. ADA Title II requires schools to provide auxiliary aids and services when needed to communicate effectively with people who have communication disabilities, such as a vision, hearing, or speech disability. Some aids and services this might include are sound amplification systems, captioning services for recorded and live communications, and accessible telecommunications services. And remember that the ADA applies to communication with families as well as students. This means that the school would be required to provide supplementary aids and services if necessary to enable effective communication with family members who have a disability. These may be parents of students without disabilities, not just the families of students who are receiving special education services. Also, note that individuals must be able to effectively receive information from the school and convey information to the school. What's more, Title II requires that the school provide technology-based support instead of a human support if the technology will enable the student to communicate independently. Let's review. Which three laws govern provision of assistive technology for public school students? Individuals with Disabilities Education Act, IDEA. Rehabilitation Act, Section 504 specifically, and the Americans with Disabilities Act, Title II. Question 2. An assistive technology device is used to increase, maintain, or improve the functional capabilities of a child with a disability. True or false? This is true. Review question 3. Schools are required to provide AT devices only, not AT services. True or false? This is false. IDEA requires that each public agency must ensure that assistive technology devices or assistive technology services, or both, are made available to a child with a disability if required as part of the child's special education, related services, or supplementary aids and services. Review question 4. Schools only have to provide AT when there is a budget surplus. True or false? This is false. IDEA says that schools may not unnecessarily delay the provision of AT devices and services due to funding issues if a child requires the devices and services to benefit from the IEP. Review question 5. A student with a disability must qualify for special education services in order to receive accommodations. True or false? This is false. A student is not required to be eligible for special education services to be protected under Section 504. Review question 6. A school is required to provide a technology-based support instead of a human support if the technology will enable the student to communicate independently. True or false? This is true under the Title II of the Americans with Disabilities Act. For more information on AT and the law, see the Technical Assistance Document, Assistive Technology for Children and Youth with Disabilities, IDEA Part B. It's on the Oklahoma AbleTech website under Programs for Children and Youth.